Jack through window, no big city lights, just greenery. I don't know what you come for. Listen up, my dear, we're such a man free. Welcome to the land of many faces. Not one, not two, but 6 different races. You know when the sun kisses your skin, you're in the right place. Guyanna, oh, that's my beautiful country. One people, one nation, one destiny. Don't stop for a minute. Come, let me take a walk. Wait for the ticket. You'll see our landmarks and our monuments, just so unique. The hybrid structure, the tallest bone structure, cathedral, 176th Street, monuments, and the beautiful city hall. You know with the wind in your hair, you're in the right place. Guyanna, oh, that's my beautiful country. Look down through your window, no big city lights, just greenery. You don't know what you come for. Listen up, my dear, we're such a man free. Welcome to the land of many faces. Not one, not two, but 6 different races. You know when the sun kisses your skin, you're in the right place. Guyanna, oh, that's my beautiful country. One people, one nation, one destiny.
Good morning. Head teacher, Mrs. Chandrina Welcome Lee, teachers, board chair, members of the board of directors, PTA, president and members, students, distinguished guests, esteemed panelists, and to all of you on virtually with us, a warm welcome to all of you to what I hope will be a riveting panel discussion on the Guyana-Venezuela border controversy, where we'll dive into the complexities of this ongoing issue. Today, we delve into the intricacies of this long-standing controversy that has captured international attention. You are joining us as we navigate through the historical, political, and economic dimensions of this complex issue. Our aim is to shed light on the various perspectives and implications of its historical, political, and socioeconomic dimensions. You will hear about concepts surrounding sovereignty, borders, and international law, and how those intersect and relate to each other, and more importantly, how those abstract sounding words can and do impact our everyday lives. We have brought this to you at the invitation of your school, the Bishop's High, which evidences our commitment to fostering a school system which engages in discussing serious national issues of state, which will help you to develop critical thinking skills, foster civic engagement, and promote a deeper understanding of your country's challenges and opportunities. By exploring subjects such as these, you get to gain a broader perspective, learn to analyze complex issues, and form your own informed opinions in a country with a government which encourages active citizenship and empowers young people to contribute positively to their communities. We hope you will leave here well informed and that you will continue to participate in discussions such as these so that you can actively participate in shaping the future of our dear country. I am Priya Manik-Chan, your Education Minister, your humble servant, and it is an honor to moderate this discussion and navigate through the diverse perspectives that will be shared here today. So let us embark on this intellectual journey together, seeking a deeper understanding of the Guyana-Venezuela controversy and its implications for both nations, their people, and the wider international community. Today we have with us three esteemed panelists. I don't think you could have heard from a more distinguished bunch. Anil Nandalal, Senior Counsel and Member of Parliament, is our country's Attorney General and Minister of Legal Affairs. He's a prominent figure in Guyanese politics. He's known for his eloquence and legal expertise. Mr. Nandalal has made significant contributions to the development of Guyana's legal system, and he plays a crucial role in shaping legislation and advocating for justice. Mr. Nandalal's dedication to public service and his commitment to upholding the rule of law have earned him respect and recognition both nationally and internationally. I give you Mohamir Anil Nandalal. Mr. Carl Barrington Greenidge is a former Minister of Finance, Foreign Affairs, and Vice President. He's known for his significant contributions to politics and diplomacy. With his extensive experience and expertise, he's played a crucial role in shaping his party's economic policies and our country's international relations. Mr. Greenidge's dedication to public service and his commitment to Guyana have earned him a respected political position in the political landscape of our country. I give you Carl Barrington Greenidge. Dr. Mark Curtin has spent over 4 decades providing unstinting service locally and internationally to tertiary education and her users. He was keen on supporting the regional integration effort in the CARICOM during this time. Through studies, research, and teaching, he's gained experiences and imparted knowledge in the areas of politics, government, and life, making him a known figure in Guyana and wider afield. I give you Dr. Mark Curtin. The format, ladies and gentlemen, and my dear students, that this will take will be that the panelists will present to you either from their seats or this podium for 5 to 7 minutes each, after which the floor will be open for questions from you and your colleagues who are online. We have with us this morning more than 20 high schools with students like yourself and teachers, where the students are joining us in their brand new smart classrooms given to them, compliments of transforming educational system. We also have, and we are being broadcast on the Edu FM, our radio station dedicated to teaching and learning, and on the Guyana Learning Channel, as well as sister television stations. So you are here in this room, but you're joined by thousands across the country and internationally who are in a virtual space with us. We begin with the presentation of Mr. Carl Barrington Greenidge.
Thank you very much, Madam Chair, for that eloquent and, I think, flattering introduction. May I start on a personal note? Bishop's High School is a place for those who haven't had the opportunity to participate in its services. It is a place almost hallowed to those who didn't attend it. I've been here, I think, twice in my life, so I'm feeling very pleased to be able to join you today, and I'm especially impressed by the number of attendees, many of whom are not members or pupils of the school. I just wanted to say that to begin with, and let me get the formalities out of the way in terms of expressing my appreciation to the members of the Board of Governors, distinguished guests, teachers and pupils from other schools who are here with us today and who may be joining us virtually later on. The topic that we are looking at today is the Guyana-Venezuela controversy. In Ministry of Foreign Affairs, the tendency is not to qualify it by speaking about territorial controversy or any other controversy. It is the controversy. And we have an international agreement, a bilateral agreement, which is so titled. And I'm going to be as clear as I can, given the short time that is available to us this morning, to speak to specific things rather than attempting to cover everything. So the question time is for you to draw our attention to anything that you think has been properly addressed. And I'll try to work with the slides, which are for a longer presentation, so that you get at least to understand what I'm saying without being completely dependent upon my voice. Okay? I'll start with the map of Guyana, a map of Guyana, and that map that you can see is intended really to be the basis of our discussion. Between Guyana and Venezuela and the United Kingdom, they agreed, by virtue of an agreement, the borders of Guyana and Venezuela. We've lost the map? Okay, you know, politicians are known for taking every opportunity to speak when they can. So whilst they're wondering what has happened to the slides, let me just say to you that the map of Guyana that you know is largely a map that arises out of the 1899, what is called the Paris Arbitration Award. And that award came about after many things, but the main thing is after pressure on the United Kingdom to agree to arbitration. This is a process between two countries when there's a dispute over something, okay? And the map, and why I would show you the map, is because you will see that that map largely reflects what you would have done at school or anywhere else as regards, okay, they don't want to see my face. I'm not so easily frustrated, so I will still allow you to see my face. I know many will object, but for the moment, what I'm saying to you is that the map is the product, it's okay. The map is the product of a treaty, specifically in this case, an arbitration award. And normally disputes over borders can be settled with reference to a range of documents. And I want to draw this to your attention from the beginning, because you might be wondering when you read the newspapers and you hear people commenting, why are they talking about this? Why 1899? Why 1966? What's the reference? What is the relevance of the Geneva Agreement? There's a logic behind this. In the old days, when people were more religious and they understood more of religion than science, the Pope used to help to decide borders. The church, and in the case of Latin America and the Caribbean, it was a papal edict, what is called the papal bull, determined the division of the world, this new world, especially between Portugal and Spain. I mention that because when you look at Venezuela's arguments, and this controversy has to do with Venezuela and Guyana, you will see that a lot of attention is paid to what Spain bequeathed to Venezuela. But there are other means. That's an old means. There are other means, especially treaties. There is what is called colonization. Who is living in the area? Who developed the area? How these borders become defined by the communities in the area. They have also the results of wars and then UN-sponsored agreements, which the countries in question embrace. So it's important to understand that a border doesn't arise in a vacuum. It comes out of one of many processes, and in the case of Guyana, these processes are well known and well defined. And I want to say to you that one of those key processes and agreements was the 1899 arbitral award, in which the two sides went before an independent international panel. The panel decided on how the borders would flow. Subsequently, the two countries, and this is at the time Britain and Venezuela, agreed that what had been reflected in the arbitral decision was checked out on the ground, and so surveyors and that type of expert were able to mark out the area on the ground, whether it is Letem, Punta Playa, Bartica, wherever. And that agreement, border agreement of 1905, is one of the pillars on which Guyana's borders have been defined. And later, 1928, Guyana, Brazil, Britain, Venezuela agreed on where the three sets of borders met. That is Brazil's, Guyana's, and Venezuela's. And normally that should be enough to last a lifetime. In 1931, they put in place some markers, which were meant to be markers that could be renewed from time to time, but it meant that they weren't to be blown away by the wind. And the countries agreed on where those markers were. They agreed on what was on the markers. I'm telling you this because some of that seems now to be in dispute, but it's important that you understand that we've arrived at borders as a result of a process. And these are the international agreements on which Guyana's borders are based, and there are probably more agreements than most other countries have. In 1962, just before the commencement of the process by which Guyana was to get its independence, Venezuela announced that it would no longer respect the agreement that it had signed in 1899, which its parliament had approved subsequently in 1907, and which the world had come to accept. The borders reflected in UN maps. And by 1965, Venezuela started to replace those maps with a map that had an area saying area under dispute. In this case, subsequent to that assertion by Venezuela, there was an agreement of 1966, at which time Britain, concerned about the fact that, or the likelihood that Venezuela, a larger and far more powerful state than the newly emerging one from British Guyana to Guyana, decided that they would work with Venezuela, and they came to an agreement which was intended to resolve peacefully what was called the controversy, not a dispute. The controversy, it was a controversy rather than a dispute, because there was an agreement. There was a legal document between the parties. And the question that seemed to be arising was the interpretation of what had happened. And Britain agreed in 1966, at the beginning of the year, and by May, Guyana joined them in that agreement, which was intended to allow Venezuela to explore the documents underlying the decision on the definition of the borders. And that is what the Geneva Agreement came out of. That's the genesis of the Geneva Agreement. And the two countries, the three countries signed this Geneva Agreement, which allowed them to go through a number of things. If the slide is up, you can see the Geneva Agreement, and the Geneva Agreement is an explanation of the Geneva Agreement, saying that it explained the reason for there being an agreement. It also gave a role to the Secretary General. It identified the means of resolving the controversy, and those means are set out not only in the Geneva Agreement, but perhaps more importantly in Article 33.1 of the UN Charter. And that agreement in 1966 started with a mechanism called the Mixed Commission. Okay, a mixed commission between the two sides, which would examine the documentation and hopefully satisfy Venezuela that there'd be no hanky-panky. 1966, the mixed commission was supposed to last 4 years. It lasted 4 years. The examination of the documents didn't lead to Venezuela being satisfied, but by the same token, it didn't lead to Venezuela being able to identify any hanky-panky, any irregularities. And therefore, the two sides had to move to choose another means of solving the problem. And the SG's task was to listen to them and choose the next means. They couldn't agree on the next means. In the end, they chose what we now know as good offices, the good offices process, which started with Alistair McIntyre and went on to close at when Norman Girvan died. The two presidents went to the SG of the United Nations to explain how they wanted to move forward. And in that case, Guyana required of the SG that the SG move to a more definitive means of resolving the problem. Complaint had been raised in 1962. We had an agreement in 1966. And we are in 2015, and the dispute hadn't been resolved. Every 2 minutes, Venezuela seemed to resuscitate this matter. So Guyana called for a more definitive resolution, namely reference to the ICJ. And the ICJ was mentioned in that list of means that the two sides agreed on, mentioned in the list of the UN means of resolution. It says judicial process, and that is what the ICJ is. It's the highest international court, the highest court of the UN system, and that court is empowered to deal with disputes between states. That reference to the ICJ is what the president of Guyana was asking for in 2015, and Venezuela was insisting at that time in the same meeting on continuing with the good offices process, whereby somebody selected, they talk to the two sides, and they see how they can go forward. This, the Secretary General decided this had to be tried one more time. It had been explored from 1970 to 2015. Nothing had happened in terms of resolving the problem. He said some dialogue was necessary, continued dialogue, and therefore he asked for 1 more year of continued dialogue. 1 more year of continued dialogue didn't resolve the problem. He asked for an additional year, and in the process of trying to get the matter resolved in the additional year, so now we are at the end of 2016, he appointed a personal representative, which personal representative would facilitate what he called enhanced mediation. Mediation is a form of dispute resolution well known to lawyers, and in this particular case, enhanced mediation was the last process of dialogue that he felt could be used, because you don't actually normally have an arbitration and then go back to negotiations. The arbitration is a process leading to a definitive resolution. But since one party refused to acknowledge, to accept the outcome of that arbitration, even the Secretary General, there's debate in Guyana over this, but let me remind you, the process in 2015 was taken over or overseen by the Secretary General of the United Nations, Ban Ki-moon, who recognized that we were going nowhere. And in fact, the dialogue that he facilitated under enhanced mediation led to a widening of positions between the countries. Instead of arguing over Punta Playa or Essequibo, we were dealing not only with these areas, the landmass, but also with the exclusive economic zone, the maritime area. The dispute was widening, in other words, and that is why the Secretary General, on the advice of his personal representative, Doug Newlander, from Norway, decided that the matter had to be solved by the court. All the other means of consequence that weren't duplications of other means had been tried, and that is how we got to the court. That is how come the representative of Guyana submitted to the court in 2018 a complaint. And the complaint was to this effect: Venezuela, in bilateral cooperation, has been insisting that the agreement of 1899, on which our borders were based, was no longer valid. Now, an agreement that is a legal agreement cannot be just vitiated when a president wakes up a morning and decides that he doesn't think that the Orinoco River and the Delta is big enough for Venezuela. He must have more. And therefore, the Secretary General drew to the attention of both presidents that this matter could only be resolved if they couldn't agree bilaterally by legal means. That's how we got to the ICJ. And Guyana submitted this question. It's important to understand it. We have not been asking the court to decide on the land space of Guyana, and most certainly we have asked them nothing about the maritime space. We've asked them this question. And these are the clever things that lawyers do. You have some here who could perhaps help me with this. Is the 1899 agreement valid, or is it null and void? Means, does it not stand? And if it is valid, what are the responsibilities and obligations of Guyana and Venezuela? Do they have to respect the borders that were agreed in 1905, or are there some other borders arising from that? If it is valid, do they have to pursue the obligations set out in the agreement? That's the question put to the court. But as is often the case with courts, before you can move to looking at the substance, you have to establish that the court has jurisdiction. In this particular case, that's part of the rules as to whether the court has jurisdiction. And you would have seen some of that on the news media over the last 2 or 3 years. The court decided it had jurisdiction. What's more important, it decided that the 1966 agreement contains a commitment from Venezuela to resort to the court if nothing else works. Venezuela claims it didn't. The court looked at the matter and says, no, you agreed in 1966, and what is more, between or during the period of enhanced mediation, the Secretary General wrote the 2 presidents saying, if they can't agree, I will send the matter to the court unless both presidents write me saying we don't want to go to the court. No such letter was sent to the Secretary General by the two presidents. Hence, you're at the court. The court process, I just want to make this as really the last set of points. The court process it's not particularly complicated, but it has several stages. You have jurisdiction. Does the court have the power? To the merits phase. What are the substantive issues? And the substantive issues will in the end turn on whether Venezuela can prove something happened since 1899 to invalidate the agreement. Can they submit such information? You will see on there are a couple of slides dealing with the name Male Prevost. And that is the name of a lawyer who was on the panel in 1899 who announced to the world that there had been some fraud. But the submission of Male Prevost has actually never been brought to the public view in the sense of a court by Venezuela. All this talking we've been doing for 60-odd years, they have never submitted that for critical examination, but they're basing their demands on receiving something like 74% of Guyana's land territory on a document that has never been the subject of any proper analysis or investigation. He published that document. He didn't publish the document. He apparently dictated it to somebody in his office, Male Prevost, some months after being given the highest national award of Venezuela, and after every single person who could have been questioned, who participated in the event of 1899, had died. And what he also went on to say is his declaration should not be, his memorandum, should not be made public until after his own death. So nobody is in a position actually to question in any meaningful way these assertions. I'm going to stop there because I've spoken far longer than was intended. I hope that's given you a sort of bird's eye view within which the various elements, whether it be Geneva Agreement, the court, and its adequacy, can be examined. Madam Chair, thank you for your patience.
Good morning. Good morning. After that very eloquent overview, I think I've left my script somewhere on that table. Honorable Attorney General Anil Nandalal, Honorable Minister of Education, Spring Manik Chan, our moderator, Madam Head Teacher, and staff of BHS, thanks for the invitation. Allow me, please, Madam Moderator, to use the language of youth and say big up to the young people here today who are participating in this important forum. Let me also commend your school for this initiative, which I hope will be the catalyst for many more of this type of fora across our country. Madam Chair, Madam Moderator, I'd like to begin with a story. During my high school days, and I went to an all-boys school somewhere on Camp Street. I think they called it Queen's College. I think the Honorable AG and yourself went to the same school when it was co-ed. During my time, there was a boy, tall and strong in the class, who sought to bully a less physically endowed classmate. This class bully sought to create allies by buying goodies for some of us in what we used to term our tuck shop, known as the canteen today. It came to a point where we had to rally around our weak classmate forget the goodies and ensure that first through dialogue, which failed, and later through adjudication by the principal, I think is now head teacher, there was some remedy to the situation. To ensure that the class bully complied with the remedies prescribed by the principal, we sought and obtained the support of colleagues from a higher form, which assured compliance by the class bully. I think, as you all know today, bullyism is treated condignly and indeed appropriately in schools and across our country. Let us now juxtapose this class bullying with the situation in which we find ourselves, with Guyana, a small developing state, which since its independence has had to face aggression from a large military strong neighbor about an agreement on the delineation of a boundary which since 1899 was deemed full, final, and perfect. After years of dialogue, intervention by good officers, as my predecessor spoke, and other approaches without success, the issue was taken to the United Nations Secretary General, much as we took it to our principal, our head teacher. And after another attempt at mediation, the Secretary General referred the issue under the 1966 Geneva Agreement signed between Britain, Guyana, and Venezuela to the International Court of Justice, where the issue of validity of the 1899 arbitrary award is currently being adjudicated. So we see some parallels. Our class bully trying to ensure that his way or the highway, and we saw interventions by our principal. And when we juxtapose that with the issues that we placed before the United Nations, even after lots of dialogue, we note that we have the final court, the International Court of Justice, being brought into play. So we see that parallel to my school days and the current situation. Now, what we see in 2023, in what I term unprecedented action, Venezuela has decided to hold a referendum, which is their right under their constitution. But one of the questions, which could be described as a leading question, and most of them are, being asked is for citizens to consider approving the annexation of the Essequibo River, which illegally belongs to Guyana. And I think that is the critical issue which we need to look at. Time does not permit full interrogation of the issues, but suffice it to say that for 6 decades, Guyana has faced significant acts of aggression, including the occupation of Guyana's half of the Ankoko Island, which was awarded to the country under the 1899 Arbitral Award. I remember that on February 23rd, 1970, as Guyana ushered in its status as a republic, a young GDF officer, a schoolmate of mine, who had just been commissioned in the Guyana Defense Force, and his platoon came under intense mortar and gunfire at Ittering Bank and had to conduct a hasty tactical withdrawal. I say that was a critical act of commitment, and I therefore thank and congratulate the members of our security forces for their unwavering commitment to our Constitution in the face of serious threats and aggressive acts by Venezuela, including the seizure of Guyana's fishing boats in our territorial waters, the seizure of a seismic survey vessel, and equally important, the use of its influence to block loans for development in the Essequibo, which have all served to constrain our efforts at improving the quality of life of the citizens of this country. The question also is, what can we do in this period of an existential threat to our sovereignty and territorial integrity? Madam Moderator, I believe that all stakeholders, government and opposition, civil society, NGOs, schools, the business sector, must all speak with one voice. This is not a time for divisiveness nor division. An informed population is critical. Daily updates, a national sensitization program, events such as this, and once again I commend the school and the ministry for supporting this activity. These must be prioritized and sustained. There must be a sustained engagement with the international community to win new friends and influence people based on the correctness of our position. I reiterate the call for a meeting of CARICOM heads before the 3rd of December, with the sole item on the agenda being the existential threat to Guyana's sovereignty and a pledge of unequivocal and unwavering support for Guyana. And I believe that there should be consideration of an enhanced regional security system to serve as part of a broader international strategic deterrence mission, which could act as a counterweight to any potential aggression by our neighbors. You, young students, can contribute to this effort in a significant way. Write and send messages using the various platforms to your young friends and colleagues in sister institutions in CARICOM, outlining Guyana's position and urging them to advocate for their respective governments' unwavering support for Guyana. Translate these messages into Dutch, Spanish, and Portuguese, and send them to your sister schools in the region to sensitize your fellow students on the issue. Create positive messages for social media. You have the talent to create and share those messages. Messages which can ensure that the 1899 Arbitral Award, which was full, final, and perfect, is known internationally. We must also understand that in 1931, a tri-junction point was created where the borders of Guyana, Brazil, and Venezuela were clearly demarcated, as my colleague indicated. And so I think those things should be known. We should also recognize that and let people know that there has been a series of dialogues, and intervention and conversations which are no longer possible, and that the International Court of Justice is where the resolution of this claim resides. I believe that we must create discussion groups and involve all from our neighboring states like Brazil, which to my mind must be seen as a significant counterweight to any potential Venezuelan aggression in the short term. I believe that the 3rd of December is not the end. I don't think that we can just look for that date as an end. I think we have to ensure that all continue to be engaged in this process. Our schools, our university, our people must continue to understand and to be sensitized significantly on the issue. I close by supporting Guyana's position, which has the concurrence of all major stakeholders, that Guyana considers that the only appropriate forum for Venezuela to raise its claim, consistent with the rule of international law and the preservation of peace and security, is the International Court of Justice in The Hague, which has already twice determined that it has the jurisdiction to resolve the claims of Venezuela. Further, as Guyana notes, resolution by the International Court of Justice assures both parties of a final, binding, and permanent settlement that is equitable, just, and consistent with international law. I close by saying, Essequibo is Guyana's. Let us defend it together. Can we do it? Yes, big up. All right. Bless up.
Madam Moderator, my sister, the distinguished Minister of Education, Honorable Priya Manik Chand, my illustrious members of the head table, the organizers of this event in particular, the headmistress of Bishop's High School, the members of the board, the teachers, and last but not least, of course, the students who have sacrificed their entire Friday morning to be here with us to discuss this important issue. And permit me to welcome also the hundreds of other students who are joining us by podcast and Skype and other devices across the country. And last but not least, in particular, those who are listening to us on the radio, in particular, in our border communities. We are meeting here to discuss perhaps the most important question that has ever faced this country since its birth as a nation state in 1966, May 26. It has been described as an existential threat because that is what it is. There is a claim by our western neighbor, the Bolivarian Republic of Venezuela, that it owns more than 5/8 of our territory, the entire resource-rich county of Essequibo. Those who spoke before me admirably laid the factual foundation spanning over a century and a half in setting out the historical evolution of this claim. But I will focus, using the broad foundation laid, I will focus on a couple of issues that I believe should be etched in your memory as we bring countrywide public awareness on this important issue. So, it all began after Venezuela gained independence from Spain. At that time, Venezuela was a newly birthed country, and whatever may have been the reason that led them to believe that British Guyana at the time, a colony of Great Britain, was in physical occupation of territory that was theirs. At that time, Venezuela was a newly birthed country. Britain was a mighty colonial empire. So Venezuela ran to the United States, and that is where it lodged the complaint. At that time, many of you are doing history, and you would have known about America trying to do its hegemony, etc., at the turn of the 19th century. It coincided with what you may know as the Monroe Doctrine. So, building on the platform of the Monroe Doctrine, Venezuela went to the US to say, look, big, powerful Britain, through its colony Guyana, is occupying a massive space of land that belongs to Venezuela. We are a recently independent country. We can't face the might of the British Empire. Please come to our assistance and intervene. And it is in those circumstances that America intervened. Venezuela, so firstly, it was initiated by Venezuela. They chose the United States of America to be the one to initiate the process on their behalf. They sat at the table with the US government, with the British government, and they worked out the modality on how this issue will be resolved. They chose the method of arbitration. Arbitration, many of you are doing A-level law, I understand. Arbitration is a legal process that two parties freely and voluntarily sign on to. And when you sign on to that process, you bind yourself to the process, and most importantly, you bind yourself to the outcome of that process. Venezuela sat there and worked with its two governments on this arbitral mechanism. The arbitration was established. Venezuela again sat there and participated in the choice of arbitrators. 2 from the United States, 2 from Great Britain, and the 4 would choose a chairperson. And the 4 did that in the form of a Russian jurist. Venezuela again was very well part and parcel of that. When the award was made, Venezuela celebrated a victory, and perhaps rightfully so. Why? Because Venezuela benefited from a landmass through that arbitral award that is 5 times the size of what we know as the Cooperative Republic of Guyana, including Essequibo. They got 5 times more. And that is why the president of Venezuela's brother at the time made a public statement that he is so overwhelmed by the award that it has realized his lifelong work. And the Venezuelan government celebrated it as a victory. They moved it to demarcate, they used it as a basis to organize the boundaries of Venezuela, as Comrade Carl Greenidge has explained, including boundaries with the award says, and they implemented it in every material way possible. And that was the position for 60 long years. For 60 long years, that was the position. No one had an objection. British Guyana lost its territory. We never said a word. British government never said a word. And life continued as normal. The events began to change when in 1960, the General Assembly of the United Nations passed a resolution that called upon colonial powers to recognize self-independence and grant independence to dependent and colonial territories. That led Premier Dr. Cheddi Jagan to write to the General Assembly in 1961 to request independence of British Guyana. And then for the first time since 1899, Venezuela formally lodges a complaint first with the U.S. State Department, which was transmitted to the UN General Assembly. And the basis of their complaint was not a legal one then, it was a moral one. And that is when it said for the first time officially about this letter from this lawyer who 40 years after, it was discovered that he wrote a letter which he directed in his will that that letter must not be opened till after his death. So after he died, they opened the letter. The letter had some spurious allegation about corruption against the judges. That the British judges conspired with the Russian judge to some James Bond kind of conspiracy theory to give away the border to Guyana, some foolishness like that. And the man said the letter must not be opened till after he dies. So you can't question him. So you know we have a saying in Guyana, dead men tell no tales. Well, there was one dead man who was telling a tale. Or HBO used to run a series called Tales from the Crypt. That was a tale from the crypt. So that was the basis. And they went to the United Nations and they objected to Guyana's independence. And that presented a platform for the Geneva Agreement. Because British felt at the time, first of all, it was never intended by the Geneva Agreement that this border issue must be reopened. That was never it. The Geneva Agreement is crafted and predicated upon the common assumption and the factual and legal basis that this issue has been comprehensively and conclusively resolved and determined by the arbitral award. That is the foundation upon which the Geneva Agreement was negotiated and concluded. It was simply an avenue to allow Venezuela an opportunity to present this controversy that it claims it has. That was all. And even before the Geneva Agreement was signed, from 1962 to 1966, they got 4 years to bring to the UN credible evidence to support their allegation of this fraud. They never did. British felt that to send Guyana into independence with this big, powerful Venezuela next to it, with this issue hanging in the air, without a dispute resolution mechanism in place, is an unsafe thing. And it is in that context that the Geneva Agreement was signed. The Geneva Agreement, therefore, simply is the mechanism by which we must find peaceful resolution of this. And Mr. Carl Greenidge has outlined the various processes. And all the processes are in the empowering hand of the Secretary General of the UN. That is what Venezuela agreed to in the Geneva Agreement. That the processes must be done under the auspices of the United Nations Secretary General. And that's what we have been doing from 1966. So we had a mixed commission. They failed again to produce any evidence that can sustain the type of allegation they were making. Then we moved to the good officer mechanism. That did not yield the type of success that we expected. And after all these processes failed, we went back to the UN Secretary General to say, look, we come here for you to recommend another mechanism. Because that is the power that you have. That is what both parties gave you the power to do. And it is the UN Secretary General that says, look, go, and as Carl Greenidge pointed out, they give both countries an opportunity to object to the recommendation. Now, what was the recommendation? Go to the UN principal judicial organ, the International Court of Justice, to resolve this dispute. And that is where we are now. Now, an important thing is, and to show, to give credence to what Dr. Mark Curtin spoke about, the bullying. This border issue, as you have heard, has been hovering over us since 1962. And at various periods over the last 50 years, it would have gained different momentum and assumed different critical stages. But where we are now is we are seeing its highest escalation. And why? This latest invigoration of energy into this matter, which has catapulted it to where it is now, is simply because we discovered oil in large quantities recently. It is a quest for Guyana's resources. We were not that attractive before the oil discovery. In fact, as I said to Queen's College yesterday, President Maduro's predecessor, President Hugo Chavez, has been a good friend to our government over the last 20 years prior to his demise. He was asked about this exact question, and he said it was an imperialist ploy. He said that it will assume the back burner on Venezuela's agenda. President Maduro himself came to Guyana. He came to Guyana as a friend. We all, I believe, went to the airport and welcomed him and so on. This is our neighbor. We concluded major agreements with them over the last decade. One that comes to mind is the Petro-Caribe Agreement. What suddenly changed? The discovery of oil. And in all their propaganda, they describe Essequibo as this resource-rich, madly referred to as some province or state of theirs. So, at the court, they have been, first of all, they don't want to submit to jurisdiction. They exercise what you call their sovereign right. And the court said, listen, you signed this Geneva Agreement. You participated for 50 years on the processes of this Geneva Agreement. It is the Geneva Agreement that recommends the court. How can you come here and say that you are not submitting to the jurisdiction of the court when you have already done so by signing the Geneva Agreement? So that argument was thrown out. Now they have to file what is loosely called their defense to our claim. And they have not been able to do so. You know why? And why they are reluctant to go to court? And why they perhaps taking these drastic and what can be obviously provocative steps, such as this referendum and the question that the referendum asked, is because they cannot go to a court of law or any tribunal of substance and present a case to support their allegation. They can't. So they invoke rhetoric, they invoke misplaced, say, patriotic and nationalistic sentiments to mislead the masses in Venezuela, to tell them all kinds of things. And that's where we are. We have approached the court as a result of this latest act of this referendum to say, court, we are before you in this matter. Venezuela is before you as well. And here it is that they are taking steps while the case is going on to do things that will affect the outcome of the case and that will derogate and transgress your jurisdiction, because this court has been placed exclusively in charge of the determination of this matter. And that's where international law has placed it. And an agreement signed by Venezuela has placed it. To run on a track that collides with that is not only disrespectful to the court, but it's a violation of international law and an attempt to subvert international legal order and international legal process. And that is why we have been able, as a country, to secure widespread support and solidarity in this region and beyond. The Organization of American States, the United Nations, of course, the Commonwealth, the CARICOM, and all major countries in this hemisphere are standing with Guyana. Why? Because we are on the side of righteousness. We are on the side of diplomacy. We are on the side of the rule of law. We are on the side of justice. And that is why when we say that Essequibo is ours, it's not an empty rhetoric. It is a pledge and a plea that is grounded in fact, history, law, justice, diplomacy, and all the international concepts. So I will stop there. I'm sure that I've exceeded my time. I will stop there, and we will now await your questions. Thank you very much for your attention.
Thank you to our panelists. So we heard how even before independence, over 100 years ago, our borders were full and perfectly and finally settled. We heard how when we were coming up to our elections, our independence, there was a question again. And again, there was a settlement of any quarrel about who Essequibo belonged to, and it belongs to Guyana. We heard how subsequent to that, there were questions raised, and at every turn, the questions were always resolved to say that Essequibo belongs to Guyana. We heard how throughout all of this, Guyana, every government, her people, and her friends and allies around the world have maintained resolutely that we are a lawful people and that Essequibo belongs to us. We heard how when we started getting recognized for resources here, that this controversy rose its ugly head again. And we hear the views of our panelists, esteemed panelists, that this controversy is really about a grab for resources. Our resources, your resources. That allows you to ask any question here this morning. And I invite you to ask anything. There's nothing that is wrong. There's nothing that would be too hard. The panelists will answer all your questions. I want to recognize in our midst this morning the Charlestown Secondary School, Brigham Secondary School, Christchurch Secondary School, Richard Ishmael Secondary School, North Rumvelt Multilateral, the Lodge Secondary School, the Marian Academy, Campbellville Secondary School, and the St. Rose's High, all invited by the Bishop's High to be here. I applaud the teachers who brought them and ask Ms. Rhonda Lamb, the beloved Marian teacher, to accept on behalf of all the other teachers who are here our thanks for bringing the children out this morning. We also have schools online with us in their smart classrooms, the Johanna Cecilia Secondary, Abram Zool Secondary, Stewartville Secondary, Westminster Secondary, Good Hope Secondary, Christianburg Wisma Secondary, the North Rumvelt Secondary, Port Morant Secondary, Skeldon High, Skeldon Line Path, Bijaval, Fort Wellington Secondary, and a Regina Secondary, who are all with us on their smart classroom. And on the radio from our border communities in Region 1, Mabaruma, Port Kaituma, and Kumaka. In Region 7, Arau to Kaikan, Ikiraku, Parima, Waramadang, Jawala. And the stations include Kaikan, Camarang, and Bartika. And in Region 8, the Kato, Madhya, Mango Landing, Tamausi, and Tumatumari, who are all joining us on the radio. I know too that television cameras from the newsroom, HBTV, NCN, DPI are also with us getting the feed of the Guyana Learning Channel. So this morning, we begin our question and answer session, and I invite you to, by show of hand, raise your hand so that I can indicate that you have a question so that we could get the microphone to you. I see hands here. Who's doing the mic for me? And I see a line coming through there. Yes, please stand and let's hear the question.
Good afternoon. My question is, what are the main challenges faced in reaching a peaceful settlement to border dispute?
So there's no border dispute, it's a controversy, but the question is, what are the main challenges in reaching a settlement of this controversy? There are mics to the panelists on the table in front of you. Yes.
Well, thank you for the question. There are, as is usual with any disagreement between two sides, it is important to recognize when there is not common ground. So the first thing is you have a party on this other side that commits itself to things by way of agreements or treaties and then denies that it does so. So that is one side. In looking at the mechanisms available to us, the Geneva Agreement, we find every day it is cited by Venezuela, the president, the vice president, and so forth, and yet their interpretation of what the agreement says conforms to no interpretation that anybody else has. Okay? The Geneva Agreement makes no mention of Essequibo. You hear what I'm saying? The Geneva Agreement makes no mention of Essequibo. It does not make any mention of a transfer of land to Venezuela. Nowhere does it say that Venezuela has to approve what Guyana does within Guyana's borders. And yet, in spite of all of that, a good deal of the presentation by Venezuela to the rest of the world and the justification for disputing what is taking place rests on those fallacies. So if common facts, if facts aren't shared by two sides, or recognized or accepted, it makes it a lot more difficult. But in the end, the problem is that one side has it in their mind that they will not stop bullying, as it were, until such time as they get some land. That is the difficulty. And we are agreed that on the basis of law, Venezuela has no rights to the territory it is claiming. In 1899, the heart of the dispute with Venezuela was about the mouth and estuary of the Orinoco River, not of Essequibo.
The simple, of course, Mr. Guyanese has given the proper answer. But let me be the devil's advocate and embrace what is the underlying thought behind your question. Why don't we settle? Settlement here will mean only one thing. We have to give up some part of Guyana. Do we want that as settlement? That is the problem. Because this thing is settled 100 and something years ago, and then you resurrect a debt claim. It's as if you living in a house with your family, you got transport and title. You had a dispute 100 years ago with the neighbor grandfather or great grandfather, but that issue went to court. You all went to settlement, you signed agreement, you build your fence around what is now yours, They build a fence around what is theirs. And 100 years after they come, have a claim half of your yard. And then they want to settle. Settle me, they got to give them a quarter. See how reasonable it is? And that is the position here.
Yes. I see. Yes, go
Well,
ahead.
I want to
Oh,
basically.
so of course, sorry, Dr.
No,
Curtin.
no, what we've seen is twice that the International Court of Justice has clearly indicated to Venezuela that they have jurisdiction to adjudicate in this matter. And we don't see adherence to the principles of international law by Venezuela. So I think that's a challenge, if one could call it that, to ensure that that bully country, Venezuela, adheres to the principles and practices of international law.
Yes. Next question, please.
Good morning. Good morning, esteemed members of the panel. My name is Ethan Blair, and I would like to ask you a question based on what you said in your presentation. First, I would like to thank you for taking time out of your busy schedule to inform us about the controversy that's happening. The Vice President of Venezuela, Delcy Rodriguez, told the ICJ that nothing will stop Venezuela from proceeding with its December 3rd, 2023 referendum, despite the legal proceeding that Guyana instituted. My question to you is, what will happen after December 3rd when Venezuela holds its referendum? What does this mean for Guyana and the citizens? Because there's a level of fear that surrounds that day and thereafter.
Thank you very much, Ethan.
Madam Chair, I'm sorry that you gave such an open slate to our students to ask questions. The simple answer to that question, if there is one, is this: we don't know. We know what we will do. Guyana has to conform to international law. It will be vigilant.
Well, Mike, please. Mike, could you help us with the mic here?
Yes, we have responsibilities. We have to protect our interests, and that is what we will do. It is likely, from what Venezuela said, that they will continue with the referendum. The key thing here isn't whether they continue with it or not. The key thing is that at the level of the UN and of the court, that it is made clear to them that they are not empowered to act on whatever comes out of the referendum. They are not empowered to act. They cannot change Essequibo's status, they cannot change Guyana's status, and they can do nothing as regards our occupancy of this territory.
Perhaps it may be impossible to try to get Venezuela to not proceed with the referendum. Proceeding with the referendum to its conclusion is one thing. Acting upon it is a completely different matter. One of the things that we are asking the court for is some type of orders to stop any actions being taken on at least 3 questions that would involve interfering with or directly affecting Guyana's territorial integrity and sovereignty. And we are asking the court not to do so. That they must not do so. So let us, for a moment, interpret the tone and tenor of the distinguished Vice President of Venezuela to the court to mean that they will not obey the court's process. I mean, we are all big and intelligent people here, and these are questions that if we are going to have a real discussion, we have to discuss all these things. So they decided they will not obey the court order. Well, by doing that, they are striking at the heart of not only international law, but international norm and the international legal order. Because they are violating the World Court order. And a court that doesn't stand alone, but stand as the judicial enforcement agency of the largest global organization on planet Earth, the United Nations. The United Nations, there is no court that will not have the ability and the capacity to enforce its own order. If you go to our High Court and you violate a court order, the judge has a power to jail you. Translating that to the International Court of Justice, the very summit of the hierarchical structure of the legal order of the world, it is unimaginable that the violation of an order of that court will go without sanctions. In addition, you are aware that Guyana has been speaking and soliciting the support of all its neighbors and important, powerful allies in the world, in recognition of the fact that Venezuela has military might and we may not be able to respond and we need help. We have recognized that. We have a major neighbor in Brazil that has established and extended its support to us. And before I put down the mic, let me make this point. The bullyism of Venezuela is demonstrated by the fact that it's not going behind Brazil. As both myself, Mr. Greenwich, and Dr. Corton said, this award determined the tripartite border for Guyana, Venezuela, and Brazil. Venezuela not interfering with the Brazilian part. They're coming behind small Guyana. Because Brazil is a big, large territory, as big as them. And the other point I want to make quickly is that they are claiming that this thing is a nullity. Well, a nullity means that the thing is void. It means that the thing never happened. But they are not prepared, so it means that anyone who benefits from it will have to forfeit their benefit because the whole process is illegal. But their argument is apparently that the nullity only applies to the part that gives Guyana a piece of land. Where they got a piece of land, the thing is valid. So I don't know how half of the arbitral award going to be valid and the other half going to be a nullity. All of that is the inherent madness about this claim. If you're claiming fraud, fraud taints everything. It damages everything. So how can half of the part that from where you are benefiting, that part is valid. But the part where Guyana seems to be benefiting, that part is tainted by fraud. Does that make sense? So that is why there's reasons like that. For the past 50 years, they have not been able to come to any sensible tribunal and articulate a case. And they can't go to the CCJ, the ICJ, and do that either. And that is why they're running.
I would just like to add that indeed we have to continue to remember that diplomacy has to continue to be our first line of defense. And therefore, we'll have to ensure we have enhanced, robust relationships with countries like Brazil, and we have to influence a greater alliance of countries, not only in the hemisphere, but I think in the African Union, We remember that we have to go to the BRICS, Brazil, Russia. We have to go to all those who have been, in a sense, on the fence. I mean, we also have to ensure that we get unequivocal support from our own brothers and sisters in this CARICOM region. Some people argue that there have been some wavering, but my view is that there has to be that kind of thinking that resides in the fourth pillar of CARICOM, which is security. And for the region to be secure, all the countries of the region, all member states, have to contribute to this high level of security. So I think there's a multi-tiered kind of response. Our people, for example, Guyanese, have to continue to be informed and be part of a process so that we continue to understand the correctness, the rightness of Guyana's position. And then at another level, my view, once again, is that with limited military capacity, we have to start thinking about what our sister states, what our allies, what about the regional security system, of which we are now a member, should it not be enhanced to ensure that not only protection from any form of aggression, but also levels of, emergencies and other issues that arise for the region. So I think that those are different levels of enhancement that we have to look at in relation to, the post-3rd of December referendum process. Thanks.
And I think it's important for us to remember that the premier body for maintaining international peace and security is the UN Securities Council. And Guyana was voted a non-permanent member of that council in June of this year, and will assume its position there in January. Additionally, the CARICOM, the Organization of American States, the Commonwealth of Nations, they have all issued, and then individual countries, have all issued strong statements of support for Guyana in this process, and particularly for support to the ICJ and waiting for their decision before any kind of unilateral action is taken. I will read for you the statement from Baroness Patricia Scotland, the Secretary General of the Commonwealth. The Commonwealth of Nations stand ready with the government and people of Guyana and with our partners in CARICOM in expressing our concern over the questions in the planned referendum. And the Commonwealth continues to stand for the rule of law and reaffirms its firm and steadfast support for the maintenance and preservation of the sovereign and territorial integrity of Guyana and unobstructed exercise of its rights to develop the entirety of its territory for the benefit of its people. I know we had a hand up in the newsroom, so I'll ask the mic to go to an adult before we revert to the children.
Thank you. Kurt Campbell, Newsroom. Minister Manichan, you just alluded to the statement from the Commonwealth, and we've had similar statements coming out of CARICOM. But earlier, Dr. Curtin reiterated a call for an urgent meeting of heads of government of CARICOM so that we could get a new pledge, a new commitment of support. I wanted to know to what extent this call finds favor with the government. The question is particularly for the Attorney General, and in answering that question, could you also update us on the collective assurances of support from the CARICOM heads of government? And this question is particularly in relation to what we've seen, the statements we've seen coming out from some heads of governments recently.
So our government engaged the CARICOM heads, and that resulted in the dissemination of possibly the strongest statement of support to Guyana thus far made. And as Prime Minister Mia Mottley and I believe Dr. Keith Rowley on different occasions pointed out, that statement embodies the view of every single CARICOM head of state and CARICOM nation state. When you read the language and the tone of that statement, there is not a single person can sense any equivocation, any ambiguity regarding that support, but unqualified and unreserved support for Guyana and its territory and its people on this matter. Whether we should have another engagement dedicatedly for this purpose is a matter that our government as a collective will have to invite the entire CARICOM to convene. It's not a decision that the government of Guyana can make and unilaterally impose on a community of about 15, 17 different governments. But what I can say is that our government is committed and has publicly said so to explore every single avenue available and every single option available in our effort to secure Guyana's interest and Guyana's people's interest. That our government is unwavering on. And let me use this platform to reiterate the government position on that. So that's how I'll answer that.
Right. So I would like to remind you of the CARICOM statement, which reads as follows. CARICOM insists that the referendum proposed by Venezuela has no validity, bearing, or standing in international law in relation to this controversy. The referendum is a purely domestic construct, but its summary effect is likely to undermine peace, tranquility, security, and more in our region. CARICOM reiterates its support for the judicial process and expresses the hope that Venezuela will engage fully in that process before the International Court of Justice, which has determined that it has the jurisdiction in the case brought before it to determine the validity of the 1899 arbitral award which Venezuela questions. And then I just want to remind you that generally in international relations, where there is an umbrella body like the CARICOM Secretariat or CARICOM generally or the Commonwealth Secretariat, and they speak, it is generally for every country that is a member state of that particular organization. So when CARICOM issues a statement, it is every member state of the CARICOM speaking to and on behalf of Guyana. I know there are questions behind me. Yes, please.
Good morning, everyone. My name is Vikram Prasad. I'm a Form 2 student of the Bishop's High School. My question to you is, well, I have many questions. So my first question is, it was a referendum that was filed legal? My second question is, who filed the referendum, and which are the countries supporting Guyana in this crisis?
Okay, panelists?
So the referendum is an internal legal and constitutional process in Venezuela. I believe it emanated from a body called some election council, somebody akin to their parliament, right? Because a referendum is normally a process born out of a parliamentary initiative. So it's something that is uniquely Venezuelan. Whether it is legal, it appears as though it is legal in Venezuela because they got a court to pronounce in Venezuela that the referendum is legal in Venezuela. But what we are saying is that we are not concerned what Venezuela does exercising its legitimate procedures in Venezuela. What we take umbrage to is when you do that, though an internal process, but that has implications and ramifications for my country next door. You see, imagine two neighbors. You can do whatever you want in your yard because you own that and you're entitled to use and enjoy your property as you see fit. But from the moment you start to do things that will interfere my right to enjoy my property next door, or worse yet, you're doing things that you're going to take over my property, then that can't be legal, at least not from my perspective, and not from any international law perspective. And that's the problem here. You understand? And the countries that are supportive of Guyana, as I've said somewhere else, the only country that I recall who have said openly that they're supporting Venezuela, I believe, is Nicaragua. All other countries that have spoken in this issue have spoken in support of Guyana in one form or another.
In other words, Vikram, the referendum is legal to Venezuela, but it's not binding on us or anyone else. What is a referendum? Because I was asked to say what that is. It's like a vote. It is a vote. So what it is, there are questions posed, and you go and vote yes or no. So the same way in Guyana, you vote for a political party where you like their policies. Here, the question is asked. For example, one of the questions is to reject the arbitral award of 1899. The next question is to reject the jurisdiction of the ICJ. And the next question is to formally take over Essequibo. So they're asking people to vote on those questions. And that's what it is. So they could ask all they want, and people could vote all they want, but it's not, those answers are not binding on us. We don't have to comply with whatever those people say. You understand that? Right. I want to especially shout out Baramita Primary School on the border, who is looking in on the Cuebana Primary School, who is also a border community where their students are riveted to their screens, paying attention to your questions and the answers that follow. The next question, please.
Good morning, panelists. My question to you is as follows. Do you believe that the Guyana government has been too lax about the influx of Venezuelan immigrants? And do you think this situation can pose a threat to our national security?
I think the panelists came thinking they were dealing with students and they were very relaxed. I see them getting slightly tense now.
We are aware, I'm sure, that young people ask the hardest of questions. That's my experience. Now, Can you just repeat the second half of the question for me, please? AG is helping me, but I'm not, I don't want to.
Do you believe that the Guyana government has been too lax about the influx of Venezuelan immigrants? And do you think this situation can pose a threat to our national security?
Thank you very much, my dear. My apologies for that. What I wanted to answer the second part first. Of course, a large influx of persons unknown is always a potential threat. And one has to monitor that carefully if that threat isn't to materialize. So it's the responsibility of the government and the people to ensure that they pay attention to what is going on as regards the movement of immigrants into the country, and to put in place mechanisms that will enable them to do that. Now, the question of whether we should have done anything different as regards the influence, let me say to you
Can't hear
that
you, Mike.
Yeah, sorry. Whilst I was Minister of Foreign Affairs, I emphasized the fact that we have responsibilities as a country globally, and we have responsibilities as a country in the region. We also have a responsibility arising from the fact that Guyanese are amongst the people that move every place and any place, certainly within the last 50 years. There are few places you can go and not find a Guyanese. And in those circumstances, the really important issue is to ensure that when people enter your country, they are able to enjoy what the law says they should enjoy. You are not discriminating against them simply on the basis of the fact that you don't know them or that they are foreigners. Because our own people have to face the difficulty of living in foreign lands, which has included Venezuela. So in this matter, you must keep alert and recognize that you have rights as citizens of Guyana, and others who are visiting have rights also, not all the same rights, but that is what you have to do. Respect the rights and respect your law.
Good. Thank you, Carl. But as a member of the government, I feel compelled to speak on this issue, as it's a question that, well, it's an issue that is out there and is occupying the minds of people. So any examination of the world will show that where there's an increase in economic prosperity, there's an increase in migration. So after we found oil in commercial quantity, we began to see to Guyana an increase in migration trends. Venezuela, Brazil, and other parts of Latin America and the Caribbean region. And that began since then. That's the first thing. Secondly, as we speak now, there are still more Guyanese living in Venezuela than there are Venezuelans living in Guyana. Guyanese, as Mr. Greenidge explained, left these shores in the droves in search of a better life, as Venezuelans and others are coming to Guyana in pursuit of. The government statistics and analysis have revealed that the persons who have come from Venezuela are more than 80% of them are Guyanese returning and or with their children. Guyanese who have migrated to Venezuela are coming back, but now they're coming back with Venezuelan children and Venezuelan husbands. But there is also a number of Venezuelans that have come outside of the Guyanese network. When they come to your country, you are required to treat them in accordance with international law in relation to migrants. As I said at Queen's College yesterday, we can't want to rely on international law, secure the support of international organization in compliance with international law in the border issue because it suits our narrow interest, but when it comes to international law in relation to migrants, we disobey and we disregard. We can't do that. If you listened to the Venezuelan vice president to the court, she made the exact allegation against Guyana, that we are practicing xenophobia against Venezuelans, which is a complete and utter falsehood. In fact, we have done the opposite. We have accommodated them, and so far we have seen nothing in Guyana apart from one or two isolated incidents that would suggest that the Venezuelans who are here, whether they're Venezuelans proper or Guyanese migrants, have done anything to injure our national interest. I don't know that there's any evidence of that. So we got to be wary. That's part of our responsibility. Venezuela is a bully, is a military might, and it's wrong. But it's wrong and strong. So it is looking for a trigger. If we are to ill-treat persons, Venezuelans perhaps, that can be the trigger that they're looking for. So they can come in to rescue and arrest a situation of Venezuelans being under attack. And that's part of our responsibility as citizens in treating with this matter. So I'm happy that you asked that question, and I'm happy that I got an opportunity to speak on it.
Madam Moderator, I just want to add myself that indeed Guyana has been a very hospitable country, always interested in humanitarian support for all. I believe, though, that we can look to enhance our migration management program by seeking the support, further support of international agencies. I mean, there's the United Nations High Commission for Refugees and the International Office of Migration, both of which have had significant experience with this type of process. And if it is necessary, then one might want to recommend the kind of enhanced process, which would not only satisfy the security component, but ensure that the people the migrants who arrive, some call them economic migrants, are treated fairly, but to ensure that we have a total registration where they are, also given their biodata, for example, photographed and registered, structured. And I hope that, I understand that this has begun, but I believe that it could be enhanced, utilizing the experiences of those international organizations. Thanks.
Right. A good time to remind you that we in this generation, and I'd like to say proudly, I hope, we in the school system are not going to be backward and suffer from any phobias. And I ask you to look up the meaning of xenophobia. It means the dislike of persons from different countries simply because they are from different countries. And we know that's backward, right? So we will not be engaging in any xenophobic behavior. Yes, ma'am. And this is a student from a different school.
Good morning. My name is Crystal Chan from New Campus Secondary School. And my question for you is, what are the key legal arguments and claims made by both countries regarding controversies between Guyana and Venezuela?
What are the key legal arguments and claims?
Made by the countries regarding controversies between Guyana and Venezuela.
What are the key legal arguments and claims being made by the two countries? So a good response would be to list out what Venezuela says, A, B, C, and what Guyana says in response. Might summarize the presentations.
Well, I hope that I can answer adequately, because you are asking a very, very broad question. On Guyana's side, and if I might restrict myself to the court case, on Guyana's side, Guyana is arguing that it is in conformity with international law to embrace what follows from the 1899 award. The 1899 award has two parties. It sets out rights of Guyana, it sets out the rights of Venezuela. It says where the borders of Guyana ends and where the borders of Venezuela ends. That is what we have drawn to the attention of the Secretary General to the attention of the court, and asked the court to clarify, confirm that these are our rights. That is what has happened there. As regards Venezuela, we have yet actually to see Venezuela's arguments as regards why the agreement of 1899 is not valid. The issue turns on a claim by Venezuela that the 1899 award, the agreement, is invalid. And as I've said, you had preliminary exchanges, such as whether the court has jurisdiction. Those are arguments put by and rejected by the other side. But the heart of the issue of controversy before the court has to do with whether 1899 is valid or not. And our case for validity has been made in a memorial of over 400 pages to the court. Venezuela has to submit its argument by the 8th of April next. And that has not yet happened. What they will say, I don't know. We have some idea, as I mentioned to you, there was an allegation by a man made in 1949 that there was some fraud associated with the decision. But insofar as we are aware that that is where they pinned their argument, that was even rejected in November last by our lawyers at The Hague, suggesting that this was speculation, they had not submitted any information, and therefore the court is not in a position to act on what has been aired so far. That is the issue.
Yes. So I will ask the panelists to offer from Dr. Mark Curtin to Mr. Carl Greenidge and then A.G. Nandalal to offer their closing remarks this morning.
Thank you very much. First of all, I'd like to say that it was indeed a pleasure both to present to you and also to field some of the questions which I think were very expertly addressed, and questions which I think are important for ongoing responses. In my view, there must be sessions such as these, which not only on December 3rd or before that, but a continuing sensitization program, interactive sessions with Guyanese at one level. At the second level, I would recommend that the diplomatic effort be enhanced, not only with our neighbors, and you know I'm one of those who advocate a very robust, a stronger relationship with the neighbor which could be a counterweight to any Venezuelan aggression, and that is Brazil. And in the wider hemisphere, that we seek more support, international support, regional support from the countries in the region. In South America, we have countries like Colombia, which has similar issues, similar boundary issues. And I think that calls for a greater level of interaction. And as the cycle or the circle, the concentric ring of international relations continues, I think the United States and the BRICS and the African Union, the Vatican, also all of those important areas must be explored in terms of understanding the correctness of our position and ensuring that we come out with an increased number of allies and alliances which add to our position. That would be my closing remark, Madam Chair. And just to say thanks again and bless up to those young people.
Unless you want to come here. You want to come here?
No, I can manage from here. Thanks, Madam Chair. I was only looking. I was looking at a young lady at the front of the group.
So, because this is our old student and from the Bishop's High School, and so if we could get the mic to the front, please. And you have a loud voice. You look very gentle.
Thank you. I thought the presentation by the panel was very good. But one of the things I always remember, when I was in the US, I did a course in political science, and my instructor was from South Africa. And we went to South Africa with her, and I asked her, said, how come you all, what happened in Africa? So, yes, and she said to me, if we knew anything about manifest destiny. I said, what's that? And she says, well, you all read up on it. And when we get back to the US in the next class, we'll deal with that. So when we got there, she asked us what we knew about manifest destiny, what we knew about the white man's burden by Kipling, and all these other things. And at the end of the day, what she was trying to say, that any of us who came back to Guyana, that was an analysis that we should understand, and how these international laws are made with whose interests, right? I came back and I asked Dr. Jagan, and he told me that we must always be concerned about the external imperative. Don't bother, but not don't bother, but pay attention to that, because our legal politicians, it was a different perspective they had in what was happening here, So when it really occurred to me what he meant was when we had our political debacle here, and Mr. Pompeo came down, and we knew what was happening in the US with Donald Trump, and I couldn't understand why would such an important man in the US come down here to settle our problems. So instead of having our politicians sit down and negotiate and come to an external settlement, not a settlement which was being imposed on us by the United States. And I think it's the same thing now. I would like to see us have some sort of talk with the Venezuelans to see how we could come. I had a lot of them staying at my house. When they came down, I would discuss politics with them. They will work with me. And we had a good rapport. It's a totally different interpretation than what was going on the level of the politicians over there. Therefore, I think that what I'm trying to say is that we should try to work it out with the Venezuelans and not with the US, because they have an interest in the oil here and an interest in the oil in Venezuela. We might end up with nothing. So that's all I'm saying.
Thank you.
Yeah, well, thank you very much, Madam Chair. And may I also take the opportunity to commend the ministry, as well as all of those, including the board of Bishop's High School, for putting in place this event. I was very heartened to see the response in terms of numbers, and of course one is always exceptionally happy to see it when young people are involved and when they themselves can be part and parcel of the process. I would make an observation. Part of the reason, and let me just tell you from my viewpoint, part of the reason why I almost never refuse an opportunity to explain this particular issue lies in this. We need to understand what the process is and what has been taking place. I hear the young lady who just spoke as regards the need to speak to the Venezuelans. One of the points I was trying to make, and that is why also I was using slides, so that you can't be mistaken over what is taking place. Guyana and Venezuela have been in a process of talking and seeking a solution for 61 years. If in 61 years they can't arrive at a solution, why do you feel that they haven't spoken enough? Why do you feel that another 10 minutes of talk is going to make a difference? You can't keep doing the same thing over and over again and expect a different result. This is if you like, this is one of the things that Einstein embraced and a lot of us should learn. The problem is, if the other party wants what you are not in a position to give, then you have to find an alternative way of solving the problem. That's why you go to a court. You go to courts because the court will take a decision when the persons involved cannot themselves find a mutually agreeable resolution. And that is where we are. That is the result of 61 years plus, because in the period prior to 1962, there was no what would I say, common ground either, because when we were trying, from 1907, the British government, so it's not a question of the PPP or the PNC or Guyana, the British government in 1907 drew to the attention of the Venezuelan government that there were problems with the border in certain places, as there is with every border. You may find you draw the line, but no one has gone on the ground. No one has gone on the ground in recent times. And you will find that the border goes through a river, it passes on the side of a hilltop or the side of a mountain. The river that is marked has disappeared. These things happen, and therefore you have to revisit and modify so as not to cause confusion. And what we saw is between 1899 and 1962, Venezuela absolutely refused to change anything. Whatever were the circumstances, they were not prepared to modify any inch of the border that had been handed down by the arbitral panel. I don't know whether in those circumstances you see the prospect of talking, changing anything. There are some things in certain circumstances that are not necessarily soluble. Not everything has a solution. Not everything has a solution in a specific context. And when that context, namely bilateral negotiations, you cannot work, you have to find a different forum. And that is exactly why there are 7 different options stated in the UN Charter. 7 different options. And do you know what? The first option that the 2 countries chose was not on there. It was not on there. Good offices is not amongst the list because they couldn't agree on those. So I urge you to look carefully at what is going on, not with a view to thinking that you have a solution, but with a view to recognizing that these are human beings, these are societies with interests. Some of those interests are very narrow, they're very selfish, they're very specific, and therefore it is not always going to be possible to satisfy what the other party wants. Who do you think can go on a political platform today or next year to say, listen, my party would like you to elect me as president and my colleagues, and you can be assured we look after your interests. The first thing we will do is say to Venezuela, take 1/3 of Guyana. Nobody will be, you cannot be elected on that basis. Nobody will elect you on that basis. And the process of democracy requires that you pursue avenues that are acceptable to the electorate. So if you start from there, you recognize that there are certain no-go areas, there are certain red areas. In the case of Guyana, that is the case. People forget, you know, some of our most prominent personalities and individuals in this country emanate from Essequibo. The one that comes immediately to mind is Mohammed Shahabuddin, one of the greatest lawyers produced in the region and one of the most outstanding legal luminaries, even in the context of the ICJ. When I went to the court, the first person that spoke to me there said, You know, I knew Mohammed Shahabuddin, and he then proceeded to speak to me for the next 15 minutes about the values and virtues of Shahabuddin. Dr. Ptolemy Reed, the first prime minister of this country, was from Essequibo. You have second deputy governor of the central bank. There are some of our most famous artists also come from Essequibo. The resources of Guyana are there. You are not going to get anywhere, any popularity in this country by seeking to resolve a problem with Venezuela by yielding to their demand for resources that don't really belong to you. Those resources are the patrimony of the whole country. Everybody has an interest in them. They must have a say. And Mr. Maduro can't wake up a morning and decide, well, I signed something last week, but I don't like it anymore. I must get some more territory. As was pointed out by the AG, we agreed to give Venezuela the estuary of the Orinoco River. The Orinoco River, we think as Guyanese, of course, we always have an inflated importance of ourselves. The Essequibo is not the major river of this subcontinent. There are bigger rivers, okay? The Orinoco is one of them. And the only thing that what we have to remember is that it sits at such a critical point in the geography of this whole region that it is akin to, if you like the Suez and the Suez Canal is in the Middle East. That's its importance here. You agreed to concede that. We are not in a position to simply give up something that Essequibo. One of the reasons, perhaps I should just say this, Madam Chair, one of the reasons, if you look at why it is that Venezuela is so persistent, there are the issues of resources, but it is also the case, the Essequibo runs the length of Guyana. It runs from north to south. Its most southern point was only discovered within the last 40 or 50 years. Because we are the ones that have been working on it and using it. It is the Essequibo that gives you access to all of the southeast of Guyana and to a good deal of the south. If you had a relative who went to work in the Rupununi in the 1920s or the 1930s, the only way they had access to that part of the country was via the Essequibo River. That's where the songs of the boatmen come from. You walk, whether it is to Kurupokari or some other point, you meet just below the falls. You have to take the boat off the river, put it on your shoulder, or tie a rope to it, and drag it around. Without that river, we would have had a lot more difficulty in exploring the land. And the point is this: Venezuela has an interest in Essequibo River for more than gold. It is also because it is about, I think, between the furthest point south on the Essequibo and Suriname, it's a matter of a few miles. It is therefore of strategic importance, of military importance. If you control that river, you control Guyana, you control Suriname, and you also have critical access to Brazil. So we can't go through all of these things. This is a limited presentation. But you need to understand it's not simply a question of one party not wanting to talk to the other. It is not simply a question of one party not wanting to talk to the other. It is of one party making demands that are unreasonable in all senses. I'm sorry for taking so long, Madam Chair, but that is a dimension.
I want to once again reiterate my gratitude to Minister Manik Chand and to the organizers of this event, and of course to the students both here and joining us on the e-platforms, to thank you for the time that you have spent with us this morning in discussing these important issues. Hopefully we leave here far more informed than we were when we came, and that's the purpose of the exercise, to bring greater public awareness to these matters of national importance. We await the decision from the ICJ in respect of the referendum, and we are hoping to receive a notification of that ruling before the 3rd of December, the date scheduled for the referendum. We have to firstly continue to stay united and unified as a people on this issue. From its inception, whichever government was in office and whoever was in opposition, we united at the political and leadership level and across every single divide in this country on this matter, and we have to continue in that regard. Carl Greenidge is the agent that presented our case and who is presenting our case at the ICJ. At the time when the case started, he was the Minister of Foreign Affairs in a different government. When we took over the government, we never changed Carl Greenidge. We kept Carl Greenidge as Guyana's agent, because that's the type of position that we have taken on this matter from the beginning up to now. And we expect this to transcend right across the length and breadth of our country on this matter. We can't be divisive on this issue and expect support and solidarity from external forces. So that's the first thing. Secondly, we have to be responsible in what we say and what we do, in particular, since we now have this great access to social media and all these technological platforms. Wars have begun by wrong information and wrong images being disseminated by irresponsible persons. As I said, the more Venezuela is pushed against the wall, the more desperate it will become. Today, in the news, it is reported that the opposition leader of Venezuela is calling on President Maduro to withdraw the referendum. So in Venezuela itself, there is an implosion. That is going to put more pressure on the Venezuelan government. They are going to hold on strong, they are going to be more defiant, and they will look for excuses to justify their positions. Let us not present those opportunities. We are on the right side. We are on the side of justice. We are on the side of the rule of law. Let us don't tarnish our good image and record so far. The last point that I want to make, and the last appeal that I want to make to you, is please remain vigilant and continue to build your knowledge and continue to follow the events as they are unfolding. From all indications, this issue will not disappear after December the 3rd. Perhaps it will become a little more intense, intensified, and complex after December the 3rd. So don't think that after the referendum, this matter will, we go on with life. We will have to deal with this issue now for the next couple of years. The court matter will not be determined until after 2025 from all indications. So we have at least 2 or 3 more years at the International Court of Justice. In the meanwhile, I can't imagine that Venezuela will do such a 360-degree turn that this thing will disappear into thin air. Even if there's a replacement of Maduro's government, you will have some semblance of this thing with us. So we have to continue to educate ourselves. They have been teaching it in their schools since in the 60s. Perhaps we should address our minds to doing that. And we have no better person in our audience than Her Excellency, the Minister of Education. So these are things that we have to do going forward so that you, our future generations, can become even more knowledgeable and educated than us dinosaurs on this stage. Venezuela, Essequibo is ours, and we will stay the course resolutely. Thank you very much.
Thank you to our esteemed panelists. This morning, we sent out to, the Ministry of Education sent out to every school, public and private, activities. We expect the children, the learners, teachers, the entire school community, parents of those learners and guardians to undertake within the next week, but particularly next Friday. We sent out suggestions of poems and drawings and acrostics and a story that can be told to children and maps to color. And so after over 100 years, I think it's the first time the Guyanese education system is responding to a live issue on the Essequibo, Guyana-Venezuela controversy regarding Essequibo. It doesn't end there, that is the beginning. Our curriculum will be reformed so from nursery to secondary and even post-secondary incorporate learnings about the Guyana position on this matter very, very shortly. So what is it we learned here today? And I'm going to ask you to remember this adage, each one teach one. But I'm going to ask each of you to tell at least 5 persons your age and 5 persons older than you what you learned today. Because to whom much is given, much is required. What is required of you? What is required of you going forward from today? You will be required to stand resolutely and firmly declaring that Essequibo belongs to Guyana and taking every action that is necessary to make sure that is a reality. We're going to have to ask you to be vigilant, to be alert, to be sensible and measured, to resist any kind of action that would place you in the category of bullies, to resist any kind of action that would place you in the category of being a backward, xenophobic human being, to resist any kind of action that would place you into the category of panicking unnecessarily. This morning, you were exposed to a very rich discussion on its historical value, its impact socially and politically and economically, and legally. The Venezuela-Guyana controversy regarding Essequibo. This morning, I want to thank you all, begin by thanking our panelists for being here, being very well prepared and very patient with providing answers to us all. I recognize and want to thank specifically the head teacher, teachers, and board members of the Bishop's High School, and the PTA members also. I recognize in our midst the regional chairman of Region Number 4, Mr. Daniel Siram. I thank you all, students, those here with us, and those watching online and listening to us on the radio, for giving us your attention. We have work to do. So as we go out, remember, each one, teach one. I thank you, and God bless you all.